Alex here with a legal nuts and bolts video on contract unconscionability. I originally wanted to do a video on prenuptial agreements and how you can get them basically thrown out. And it's not just to help people throw them out, it's actually just as important to let people know how they're not a sure thing. So I mean, it's just as much that. Hopefully you're not taking it as a video. Well, I'm not even on that video now. But anyway, I wanted to cover prenuptial agreements and child support waivers and how they don't hold up, at least not all the time. But before I go into those, I should at least go into contract unconscionability, because that'll explain to people the whole principle of voiding a contract, just just talking contracts only and not those other two topics that I mentioned. Those are going to come up after this video. So this video is going to be a little bit technical, but I realize a lot of people actually are here because they want to hear that stuff, and it's not really, it's a tough channel sometimes, especially with some of these videos, but I'm just going to go right into it. So in law, there are contracts. A contract is basically an agreement between you and somebody else, or sometimes with multiple people involved. The principle of contract unconscionability is basically a legal principle that allows you to have a judge declare either a whole contract or portions of the contract unconscionable and therefore unenforceable. That's the key word, really. You're basically saying, yeah, I signed this, but it's unenforceable. Yeah, I signed this, but ignore it. Yeah, I signed this, but it doesn't matter because of X, Y, and Z reasons. And those reasons have to basically fall under contract unconscionability. As I mentioned, I do intend to do those other two topics right after this video, so try and get through this video because then you'll understand the next two videos if you care about prenups and child support waivers and other things like that, because I know a lot of this channel is child custody and divorce cases. So to have a contract, and this counts for all contracts because this is legal nuts and bolts, I'm talking about all contracts right now. To have a contract voided as unconscionable and unenforceable, you have to show two things: substantive unconscionability and procedural unconscionability. If you show one but not the other, it's not enough. The contract is still enforceable. You have to show both. So I'm going to go straight into those now. Procedural unconscionability, and I'm not going to get super technical. You can go into the case law and learn all about it in your own state by looking up that key phrase in like scholar.google.com or whatever, Westlaw or LexisNexis. Procedural unconscionability is, in a nutshell, basically speaking, playing tricks with the language of the contract. So putting really tiny fine print that's hard to read, or say you make a contract and you have like these categories everywhere, and you put like some language in a weird category that doesn't make any sense that it's there. Basically, you're being sneaky with the wording. If you can show that any of those things that I mentioned, those are just examples. As I mentioned, fine print, putting language in weird, misleading areas, using weird phraseology that just leads people to believe the wrong thing or to believe that something's not important. You can show that the contract, or just even that portion of the contract, is procedurally unconscionable. But as I mentioned, if you only show procedural unconscionability, that's not enough to have a contract voided. And many people would come to me and say, well, hey, there's fine print in all contracts, all over the place. So why aren't all those contracts voided? Well, a lot of times it's because the fine print isn't considered unfair. Well, I'm going to go into the next thing. Isn't substantively unconscionable. So even though it's procedurally unconscionable, it's small, hard to read, it's in a weird spot, it's not substantively unconscionable, and therefore it's okay that it's in fine print. It is enforceable. So now I'll go into the second thing, which is substantive unconscionability. Substantive unconscionability is, again, in a nutshell, basically, that means if you want to know the details, go look it up yourself. Unfair, oppressive one-sidedness. So if you can show that something is unfair, oppressive, one-sided, but it's like in big, bold, black letters right there, in other words, it's not procedurally unconscionable, it's enforceable. Even though it's unfair, even though it's lopsided, I mean, you can't show that they're messing around or playing tricks with the language because it's big, bold, in your face. You can't miss it. So to have a contract voided, it's actually really hard. You have to show that it's oppressive, one-sided, and that something is really sneaky about the placement of that language. And if you think about it, that kind of makes sense. People shouldn't be writing contracts and like doing shady crap like that, and putting like unfair terms in it where you're not going to see it, and then you sign it, and then next thing you know, you're finding out you're in court and you're totally screwed because you didn't even know you agreed to something because they were so sneaky with it. So most people probably are going to be happy to hear that you can't just void contracts so easily. Well, I'm going to end the video there because that's true. You can't void contracts so easily. There is a way to do it, which I just mentioned. You have to show procedural and substantive unconscionability. There's also other contract terms out there, like that there should be like a meeting of the minds and all that other stuff. But I'm not going into any of those videos because it's not really going to get to you know, the basics of what I wanted to talk about before I got into prenuptial agreements and waivers, child support waivers. But there is one thing that I do want to mention, even though I don't want to cover all those other small contract topics. I do want to cover something called something known as adhesion contracts, and I'm going to probably do that 3 or 4 videos from now. And that video, I think, is a must-watch for anyone who wants to know why contracts like, say, maybe your cell phone contract or like your cable contract, why those types of contracts don't have all kinds of really bad terms in them, because people don't really read them. And the reason people don't read, you know, cell phone and cable contracts is because everyone knows that there's no way you can change it anyway. If you call Cox and you say, hey, I don't like these terms, I want to take them out, they're just going to say, no, go be someone else's customer. Anyway, I'm going to explain adhesion contracts and how that extra principle on top of what I just talked about now, contract unconscionability, why that, how that comes into play first of all, and hopefully once you understand adhesion contracts, you'll understand why those other contract types that I mentioned, cell phone and cable and other things like that, why even though nobody really reads them, they're pretty much fair for the most part. I mean, they do have some annoying things in there, but it's not like anyone signing something like if you break the contract, you have to pay $10,000 or, you know, there's a reason there's no crazy things in those. And anyway, that's what I'm going to cover in the video on adhesion contracts. So with that, I'll go ahead and end this video. If anyone has any questions on contract unconscionability, specifically substantive or procedural unconscionability, go ahead and post it in the comments below, and I'll try to answer to the best of my ability. One last thing I forgot. There's a little blurb I read in a Supreme Court case in Nevada that mentioned that the court applies a sliding scale to the whole analysis of procedural and substantive unconscionability, in that if you show a tremendous amount of procedural unconscionability, you only need to show a little bit of substantive unconscionability to have that provision voided. So if you can show some really, you know, disgustingly sneaky tricks with that language, I don't know, making it maybe like font 0.4 or something, then you don't need to show that it's as unfair as if it wasn't quite as sneakily hidden in the language. I mean, it's hard to, I don't know what other word to use. It's hard to really put an exact science to it without going into these specific cases, which I'm not gonna do. The other thing, of course, I wanted to mention that there's another side to that coin. If you can show that a term is extremely, extremely one-sided and oppressive, like monumentally unfair, then the same principle applies. You don't have to show as much sneakiness with the language, as much procedural unconscionability as you would. Then if it was just, you know, if it was still pretty unfair and oppressive, but not as bad, not that bad. So with that, I'll go ahead and end this video and see you guys next time.